Okay. Mr. Kimsey on, there's a lot to these two. Mr. Kimsey, on January 24th, 2024, you appeared before this court and entered pleas of guilty as follows. In 23 CR 231, you pled guilty to burglary of a vehicle, level 9, non-person felony, count 3, theft of a firearm, level 9, non-person felony. In 23 CR 226, you pled to count 1, theft, level 9, non-person felony, count 6, theft, level 9, non-person felony, count 8, theft of a firearm, level 9, non-person felony, and count 5, misdemeanor theft, class A misdemeanor. Court accepted all of these pleas in both of these cases, found you guilty of these counts. Have the parties had plenty of time to review the pre-sentence investigation report?
Sure. Yes.
I should say reports.
I have, Your Honor. I've reviewed the criminal history score of E with Mr. Kimsey, and he does not object.
All right. So no objection from the state as a criminal history worksheet?
No, Your Honor, I think we have some complicated arguments in regards to special rules and stuff like that. But as far as the criminal history worksheet and the designation of E, I think it's appropriate.
All right. Any objection to the criminal history worksheet, Mr. Pate?
No, Your Honor.
All right, Mr. Kimsey, do you admit the criminal history set forth in those worksheets is correct?
Yes, Your Honor.
All right, I find the defendant's criminal history score is E in both cases. The primary crime is count 1 in 23 CR 231, burglary of a vehicle, level 9 for non-person felony, and the primary count in 23 CR 226 is also, it's count 1 in that case. That's theft, level 9, non-person felony. Regarding count 1, burglary of a vehicle in 23 CR 231, I find the presumptive guideline sentence for that primary offense as a prison term of 9 to 11 months, with standard sentence of 12 months, post-release supervision duration of 12 months, and a probation duration of 18 months. You do fall in the presumptive prison per special rule, but it's also a mandatory treatment Senate Bill 123 case, so I think the rule of lenity probably applies, but I'll listen to any arguments about that. Let's see. Regarding count 3, theft of a firearm in 23 CR 231, I find the presumptive guideline sentence for that offense as a prison term of 5 to 7 months with a standard sentence of 6 months. And I'm not going to say it every time, but all of these fall in the presumptive prison per special rule category with mandatory treatment Senate Bill 123 case. So I won't repeat that anymore, but it's true for all of the felonies. Okay, regarding count 1 and 23 CR 226 theft, I find the presumptive guideline sentence for that primary offense of that case is a prison term of 9 to 11 months with the standard sentence of 12 months, a post-release supervision probation duration of post-release supervision of 12 months, probation duration of 18 months. And I think actually the probation duration of in 23 CR 231 is 18 months. I think I said it's 12. No, I had it right. I said probation duration of 18 months. It's a Senate bill case. Okay. It's complicated. Regarding count 6 of 23 CR 226 theft, I find the presumptive guideline sentence for that offense is prison term of 5 to 7 months with a standard of 6 months. Post-release supervision 12, probation duration to 18. Count 8, 23 CR 226 theft of a firearm. I find the presumptive guideline sentence for that offense is 5 to 7 months with a standard of 6. Post-release supervision of 12 months, probation duration of 18 months. All right. Count 5, 23 CR 226, that's a misdemeanor, punishable by up to 1 year in the county jail. All right. Does the state request a durational or dispositional departure on either of these cases?
No, Your Honor.
Does the defendant request any departures in either of these cases?
Your Honor, we're just requesting the court impose the Senate bill, which I believe does not require a formal departure motion given the state of the law.
You are correct. You are correct. All right. State's recommendations with regard to sentencing?
Your Honor, ultimately, the state has entered into a plea agreement with Mr. Kimsey by where I had agreed to request the court impose the standard number on each count for each crime on both cases. Pursuant to plea negotiations, I've offered to recommend the court consider running the cases internally concurrent but consecutive to one another. My written plea agreement is to recommend that the court follow the applicable presumptions or special rules. Pursuant to agreement, Mr. Kimsey has agreed to pay $1,816 to Mr. William Presson. The state was going to recommend that. In our written agreement, I had advised that I was going to recommend restitution for Mr. Willis. I would advise the court that Mr. Willis has never reached out to the state requesting that. Also, in regards to 23 CR 231, I would just note for the record and that pursuant to the Victim Bill of Rights in that case, I've sent that victim, according to my system, 7 letters, including request for restitution. Nothing's been returned there, so I advised Mr. Pate I was not going to request restitution in that case. In regards to the jail sentence, the state did advise that it was going to recommend the court. I said internally concurrent. I meant that to the felonies. I'm sorry. The state's recommendation was that the misdemeanor be run consecutively, but that if the court felt that probation was the appropriate outcome here, that the state would not object or the state would recommend probation to the misdemeanor as well. This has been very complicated. I want to thank Taryn. I don't know if she's around. She did a lot of work dealing with the Kansas Sentencing Commission. It was anticipated by the parties that these special rules 27 and 29 were going to be applicable to these cases, but also pursuant to the new expanded SB 123 plus that Mr. Kimsey would fall into that target population. Taryn did a very good job of reaching out to the Sentencing Commission. And frankly, Judge, I could recite everything that was said, but basically the answer is that we don't know the answer. As we all well know, SB 123 has always traditionally trumped any other special rule. What the Sentencing Commission did advise is that they don't believe it trumps the special rule for 3 or more meth possessions, which obviously isn't applicable here, but in how it should be dealt with in regards to rules 27 and 29, they were equally unclear as to the answer of that and said that it would be left up to the discretion and decisions of the courts moving forward and how they wanted to apply the SB 123 plus. But based on the nature of that change in the legislation, my consultations with Mr. Presson, who's been a very active victim in this case, I did advise him that the intent of the Kansas legislature were to give individuals in Mr. Kimsey's position an opportunity at getting help in drug treatment as opposed to incarceration. So ultimately, I think that that's where the parties have agreed. That's what the written plea agreement is that I would recommend the court, if you believed it was appropriate to impose the mandatory drug treatment, that's what I'd ask the court to do. Again, that's why I say the only confusing thing is that there's presumptive prison, but also mandatory drug treatment. I defer to you, Judge, on how you want to deal with it, but that's my argument there and my plea agreement with Mr. Kimsey.
What case is the William Presson restitution go in?
Your Honor, that one is in 23 CR 226 in regards to count 6 specifically.
Okay, thank you. All right. Where am I at? Mr. Pate, anything to present on behalf of the defendant?
Your Honor, I agree. It's kind of a convoluted situation here, but my reading of the new Senate Bill 123 is that there's nothing in there that allows the prior felony theft rule to prompt the mandatory drug treatment. Wouldn't surprise me if the legislature revisits that at some point, but we're not there yet. I think, as the court already stated, the rule of lenity would apply, and we would need to resolve any doubt here in favor of the defendant. In addition to that, I I think he'd really benefit from the drug treatment. Just reading his evaluation, he has had a pretty severe problem that I believe likely led to a lot of these crimes occurring. It actually recommended inpatient. So I think he would benefit both in this case and moving forward from having the opportunity to complete that treatment anyway. I also think it would be beneficial for the victim and the payment of restitution for him to get a chance at probation so he can hold a job and pay that down. I would say during the pendency of this case, Mr. Kimsey's been pretty open and honest with me. He's recognized that he's got drug issues and other issues that he needs to address, and he's been very sincere to me about wanting to get things right. He stayed in good contact with me. I believe, whether it was mandatory or not, that both him and the community would benefit from him getting a chance to complete the probation here. But I do think, given the state of the law, that it is a mandatory treatment that the court is required to impose. So we would ask the court do that. I would leave it to the court's discretion as to concurrent or consecutive on any various counts and charges. And I think that's all I would have, Your Honor.
Thank you. All right, Mr. Kimsey, do you wish to make a statement on your own behalf and or present any evidence in mitigation of punishment?
I just want to apologize for the inconvenience of these cases and the trouble you guys had to go through to come to an agreement. Other than that, I just hope that you go with the plea that I got in written form. I mean, I apologize.
Okay. Do you know of any legal reason why sentence should not be imposed at this time?
No, Your Honor.
All right. Well, there were several. I sat on the panel of a court of appeals years ago, and it was similar. It was to this. It was optional non-prison sanction versus mandatory treatment. And the panel I sat on, and based upon other cases that were similar to that one, the rule of lenity applied. It was mandatory treatment. It was ambiguous because it gave the court the option of sending him to prison, but it also said treatment was mandatory. And when we have that, unless there's something in the law that clarifies it, you have ambiguity, and ambiguity always falls in favor of defendants in sentencing. The theory being if the legislature needs to be clear about such things if they want certain outcomes. So the rule of lenity applies very clearly, and so I'm granting probation in these cases based upon the Senate bill. Maybe they will revisit that because I don't know if they meant to step on it, but that's what they wrote, so that's what it is. I'll establish, and regarding 23 CR 231, I'll establish count 1 burglary of a vehicle as the base sentence in that case. And for that sentence, level 9 non-person felony, I'll sentence the defendant to standard sentence of 10. That was 231. I'm in the wrong one. No, I was right. 9 to 11 months. Okay, the sentences then, the standard sentence would be 10 months. So I had that right. 10 months with regard to burglary of a vehicle, count 1 and 23 CR 231. 10 months in the custody of the Secretary of Corrections. On this sentence, the defendant may earn up to 20% good time credit and would be subject to 12 months of post-release supervision. With regard to count 3, theft of a firearm in 23 CR 231, I'll sentence the defendant to I'm just going to go with I'm gonna go 7 months. That's the aggravated. I just think there's a lot here. He's getting another chance at probation. I went a little more over his head, so I'll do 7 months on that one. I'm gonna order counts 1 and 3 in 23 CR 231 to run consecutively to each other. Moving on to 23 CR 226, I'll establish count 1 theft as the base sentence in that case. Let's see. Yeah, the base sentence in that case. I'll hereby sentence the defendant to 10 months in the custody of the Secretary of Corrections. That's the standard sentence. On this sentence, you may earn up to 20% good time credit and would be subject to 12 months of post-release supervision. For count 6, felony theft in 23 CR 226, I'll sentence the defendant to 7 months. Again, I know that's the aggravated, but just get a little more time there over your head while you're on probation. So 7 months in the custody of the Secretary of Corrections. On this sentence, you may earn up to 20% good time credit and be subject to 12 months of post-release supervision. All right. With regard to count 8, theft of the firearm, 23 CR 226, level 9 non-person felony. I'll sentence the defendant to 7 months in the custody of the Secretary of Corrections. On this sentence, you may earn up to 20% good time credit and would be subject to 12 months of post-release supervision. Count 5, the misdemeanor in 23 CR 226, I'll sentence the defendant to 1 year in the Sumner County Jail. I'm going to run counts 1, 6, 8, and 5, and 23 CR 226. They're ordered to run consecutively to each other and to 23 CR 231. I'll order restitution be paid in the 226 case in the amount of $1,816 to William Presson. All right, so grant probation, place the defendant on community corrections probation for a period of 18 months for the per the mandatory treatment provisions of Senate Bill 123. Or you be under the standard terms and conditions of probation, plus all the special conditions that are outlined in the PSI. Have you gone over those with your attorney?
Yes.
Okay. All right. So you're going to have to get into the treatment program, and you're on notice of all of that. Are you working anywhere?
No, currently I'm not working. I've been painting a house, about it right now. I could possibly have a job at Ford Motors here in town, but I haven't got the call back yet.
Okay. I need to set a payment plan on the restitution. What do you do for income?
I've just been painting, remodeling a house right now.
Well, how much can you pay each month?
Well, currently I'm not. So I just got my car out of the impound, so all that money went towards that. I'm pretty much just working to pay that off right now. So I'm really not making no money at all right now, I guess you could say, because it was for my brother. He's selling his house, so he has me painting it, but he also went and got my car for me as payment.
Well, you're well, one of the conditions is you're going to be ordered to gain and maintain employment. Is there any reason you can't work?
No, right now it's just I was working in Wichita on my mom's car. The motor started knocking, so I lost that job just because of the car that I was using. But I could still, my brother, like my brother's girlfriend or wife, she works for a agency, a temp agency that gets people like me a job. So I have a job. I just gotta get my car up and going again.
Well, I'll set it at $10 a month that you pay the first of each month.
Okay.
And you're gonna be on probation a long time doing that. But we start there. I'll excuse attorney's fees based on Staley Robinson, what I'm hearing. I know Mr. Pate's got a lot of hours into this. Or he must, I don't know for sure, I guess, but. All right. Finally, you're advised at some point in the future, you may have a right to expunge these crimes under Kansas statute. You may appeal the sentence if you feel it's imposed contrary to law, and you have 14 days from the day at which to do that. As a convicted felon, you're prohibited from possessing a firearm. You've lost the right to vote until your sentence is fully discharged. Mr. Berner, tell him what he needs to do to get signed up on probation.
Yeah, Robert, can you come on over right after court and meet with me real quick?
Yeah, I can.
All right, we'll see you in a little bit.
Okay, thank you.
I'm sorry to interrupt. The $10 a month, does that start April 1st or May 1st, or when do you want those payments?
April 1st and then the first of each month thereafter. And
Thank you. Nothing further by me, Your Honor. Thank you.
that's all I have. Is that all you have, Mr. Pate?
That's all I have, Your Honor.
I think that's my last case of the day. So,
Thank you, guys. I appreciate it.
Thank you.
this hearing's concluded.
Thank you, Mr. Pate.
Thank you.